Microphone on. Welcome back, everybody. Thank you very much for coming back. Never quite sure whether you're going to get the same audience in the afternoon as you had in the morning, but thank you very much for coming back. We're going to turn our attention now to a series of what we call microstructural issues. We'll begin with looking at the organisational requirements for trading venues and investment firms in the context of algorithmic trading. We'll then move into talking about some of our proposals around the market making agreements and tick sizes, order to trade ratios, colocation, fee structures, and then we've got a block of issues around commodity derivatives, and then we finish the day picking up the remaining investor protection issues, if you're still awake by then, and we're due to finish by 6:45 at the latest, and we may finish a little bit earlier than that, but we have to finish by 6:45 at the latest. We'll have a coffee break mid-afternoon, 3:45, 4 o'clock-ish, something like that. Otherwise, I'm afraid it's hard work all the way from now until 6:45. So the organisational requirements for investment firms and trading venues is draft RTS 13 and 14. It's sections 4.1 and 4.2 of the CP. And I've been joined on the platform by Alberto Garcia to join Rodrigo and Carsten. Alberto has been particularly working on the microstructure issues. And over to you. Or are you starting with trading venues?
No. It's going to be
Alberto, thank you.
Thank you, David. Many thanks, everybody. Regarding let's start with the organizational requirements for investment firms and trading venues that, as most of you know, I mean, they were already, most of the content that appears under regulatory technical standard was already presented in the guidelines for systems and controls that the ESMA published in 2012. Regarding these organizational requirements, I guess that there are two main elements to highlight or try to focus the discussion. The first one is that by the nature of the instruments selected by the legislators, meaning that this is a regulatory technical standard, I mean, what we have tried to identify there is the strictly minimum that should be met by investment firms and trading venues. It is true as well that investment firms and trading venues which are involved in algorithmic trading. It is true as well that ESMA has introduced a proportionality principle so as to get a more flexible approach, but still, I mean, the main problem remains, which is that given the wide range of trading venues and investment firms which are affected by this, by these standards, I mean, how can we get a right identification, which is the strictly minimum that should be met by trading venues and investment firms, so as not to compromise the orderliness of the market. I mean, this is one of the key elements that probably is worth discussing here. The second element is that in the consultation paper appear a number of elements that that were not in the original guidelines and were simply identified briefly in the discussion paper, like, I mean, the introduction of requirements in terms of outsourcing and procurement for investment firms, testing within a non-live environment, which is an element that affects both trading venues and investment firms. And of course, I mean, the underlying question of who's paying for this. Firms acting as clearing members, that did not appear in any of the elements. And in relation to direct electronic access, I mean, probably one of the elements that is worth highlighting as well is that the draft RTS introduced, I mean, considers sponsored access members as quasi-members. Therefore, I mean, they should, in practical terms, be meeting the same requirements as a member of participants for trading venue, so as to get access, that is sponsored access to a trading venue. So I pass the floor, and any views are welcome. Thank you.
Thank you very much indeed, Alberto. So, who's going to kick off the afternoon with a question or a comment on some of these organisational questions? Some comments in the far corner, please.
Nick Dutton, Batschikes Europe. Sort of three comments, slightly unrelated, but they all go to this section. The first is on the requirement on venues to test trading systems following updates. We'd appreciate some kind of concept of materiality in there. We're making minor changes to the trading system code, probably on a weekly basis, to introduce efficiencies, bug fixes, etc., and we'll do appropriate amounts of testing. But I think it should be recognized in the standard that major trading system updates, the full range of testing, otherwise appropriate. So just introducing the word material there, I think, would be helpful. Second one is member firm due diligence. This is something that we're doing anyway under FCA guidance on member firm controls. Once again, the way it's written, it's as though we have to do the full range of due diligence on all firms. It doesn't allow us to risk weight, and it doesn't allow us to play any reliance on the regulated status of firms, for example. I've had it suggested to me that the reason a lot of these requirements are in there is to capture the sort of rump of non-MiFID firms, so effectively third country firms that will still be able to access and may not be subject to MiFID standards. If that is indeed the intention, then maybe you can make it clear that you would expect different levels of due diligence depending on the participant. And then finally, on algorithmic testing, we sort of appreciate what ESMA are trying to achieve here. Once again, as written, we don't think it achieves it. So us providing an environment and replaying, for example, market data from a particular day and allowing single firms to run their algorithms into that environment, I don't think delivers much more than what firms can achieve on their own back testing. So I think in our response anyway, we'll be trying to suggest some alternatives to that.
Thanks very much, Nick. I think there's a question quite close to you as well, so let's just take that now.
Hi, Oliver Robinson from AIMA, the Alternative Investment Management Association. I suppose just to say, we support your point in terms of materiality for testing for changes as well, so we can back up with that. Also, we support the point you made earlier about proportionality of the standards and the fact there is a need to take into account the sort of idiosyncrasies and the broad variety of investment firms out there when trying to meet what we would sort of term as a regulatory objective and trying to meet particular outcomes. Perhaps the different processes in the minimum lists might not be suitable to meet those outcomes for every different firm. So we respect a little bit of proportionality there would be ideal. I suppose, building on the testing question he raised, we also have a question as to what is exactly meant by the non-live testing requirement. Does this need that mean that the non-live environment has to be responsive in real time, or is it merely say a replay function whereby you run through a set of orders as previously and doesn't respond to or new orders and new algorithms placed in by those testing using the system?
Okay, thank you. Clearly a theme across both of those sets of comments around are our proposals sufficiently proportionate? Question here, please.
Hello, Christian Vogt, Fidessa. I have a question regarding Article 21 in RTS 13, the pre-trade risk checks on investment firms. There's one pre-trade risk check relating to repeated executions, which from the reading suggests is something relevant for algorithmic trading. And I was wondering, what is ESMA's understanding of repeated execution? Is it executions being two orders being matched and I have an execution? Or is it the algo executed its source code and did something? Or what is meant with being execution? And then on top of that, as an investment firm having my own market access to an exchange, I might be able to do that if it relates to the algorithm itself. How does a DEA provider is supposed to apply this test if the DEA provider does not operate the algorithm itself because it's done by the DEA user?
Okay, thank you. Let's take responses to that batch of comments and questions then. Alberto.
Thank you. Regarding the materiality of certain testing, I think it's a good point and definitely should be highlighted in the responses because, probably it's going to be taken into account. That seems sensible. Regarding the member firms' due diligence, actually, what we have tried is to do a breakdown. Being registered as an investment firm requires that the national competent authority analyzes a certain number of items. However, we have put there a list of items that should be checked by the trading venue that not necessarily are checked by the national competent authority when a firm is authorized and registered. Again, I'm noting that because within the task force we discussed this and we try to separate as clearly as possible. If it is possible to identify something that has already previously been checked by the national competent authority, I'm sure that we will consider that. So from that perspective, I don't see any problem. Regarding the algorithmic testing and its equivalent of as other elements, at the end of the day, we have already heard views of a lot of people saying that, well, it might not be necessarily, the best way to create an isolated environment so that, trading venues where you recreate X number of trading days with all the data from those days so as to use the algo there. It is true that at the same time, it is clear that first, there is a clear mandate on level 1 saying that you have to test against disorderly trading conditions. So, there has to be a way of identifying how an algo can be tested. In any case, what we are trying to avoid is another night capital situation where all of a sudden, there has to be a clear separation between what is out there, what is being tested, and the real world. So that this is, for us probably, this is something important to be preserved, okay? It is true that what we're trying to avoid is, it's true that we introduce, additional requirements, both for trading venues and investment firms, but as I said, any alternative ideas are welcome, but always on the basis, because we cannot go beyond what is said in level 1, and there's a clear mandate in that regard. So clearly the principle of testing in a non-live environment somehow probably, should remain so as to be sure that something that is released has already, we have some assurance previously that, that has been tested. Regarding the point of AIMA, the proportionality, it is there. Again, in your responses to the consultation, please highlight as much as possible which should be the strictly minimum that should be met, rather than, a too generic statement. And the testing in non-life environment, again, I revert to my previous answer. And regarding the question from Fidesz, pre-trade controls, what we're trying to avoid here is that an algorithm, starts not reacting to the news that come. That, the algorithm is reacting always the same way, regardless of which is the incoming information. That should be like an additional test that should be run, or control, rather. A control that should be, be sure that the algorithm is reacting to incoming events. No, it's reacting automatically because it's got in some type of loophole. So this is what we're aiming at. I don't know if I fully answered your question, because there was a second half that I'm not sure to have understood, honestly.
We're just going to need to have the mic. Put your hand up again. We'll get the microphone to get the second half of your question.
Yes, thank you for your answer. I appreciate that you mean there needs to be a safeguard within the algorithm itself to ensure that certain behavior do not appear. How does a DEA provider, somebody who provides direct market access, and according to Article 26 in the RTS 13, the DEA provider is required to use the same pre-trade checks as for himself. So therefore, the repeated execution applies as well. However, the DEA provider does not operate the algo. The algo is located within the DEA user. Yep. So how can he then employ that check there?
Well, in this case, the main problem that we face is that, where we're trying to put as much burden as possible from a regulatory perspective is to ensure that the DEA provider has in place this type of control. So, it is true that probably, it is the next steps on the, but again, you can think of a situation where, in particular in cases where there is sub-delegation of the access, it's very difficult that, I mean, if we don't require that to have the DEA provider to have that in place, which is, I mean, the direct member of the, it is possible that the next steps, next links of the chain might not have this. Therefore, I mean, how it can be implemented, it is true that it might be technically challenging. Again, I mean, any type of, again, this is an answer to the consultation paper, this might not be feasible. But again, I mean, what would be appreciated, because I think that we both understand that, I mean, that this type of behavior should be, I mean, there should be some type of control on this type of situation. Therefore, any type of alternative would be very much welcome. Thank you.
Thank you, Alberto. So clearly we are constrained by the schema laid out in level 1. But as Alberto says, we're very much open to suggestions about how we can make our RTSs better fit the actual marketplace, if you consider that they don't quite do that at the moment. Very much open to that conversation. Let's keep going with comments and questions. I thought I saw a hand somewhere down at the front. Yes, please.
Frank Bauer, German Savings Banks. I just want to have a follow-up on the question raised before concerning the real-time control foreseen in RTS 13, Article 1. Well, you mentioned the real-time control in algorithmic trading, which is as a general control necessity in for post-trade control in general, but we'd like to stress a bit that certainly for medium-sized institutes, this disregards a bit the difference between real-time control and a near-time control is a marvelously technical difference, and poses, as you know, a huge technical burden on someone who's not in the focus of the regulation on level 1. And we'd appreciate if you could stress perhaps the principle of proportionality here a bit more.
Okay, thank you. Other questions or comments on this strand? Can't see any more hands. No. Okay, well, let's move on then to the next block, which is draft RTSs 15, 16, 17, 18, and 19. And that covers sections 4.3 through to 4.7 of the CP. And this is a whole block of questions around defining market making and market making obligations, order to trade ratio constraints, and provisions around colocation and fee structures offered by trading venues, and then tick sizes. I don't know whether you want to do those block by block rather than all one go. So I
think it's worth going block by block.
So let's just start with the market making set of questions then. Thank you.
Thank you, David. In this case, I mean, if we start with market making, I mean, I think it is worth, because I mean, we have preliminary exchanges with the members of the consultative working group, and probably it is worth explaining, I mean, what is said in that RTS, because it might not have been understood in all cases. I mean, we have first stated that, I mean, firms pursuing a market making strategy should notify trading venues that they intend to do that. And on that, and if they don't do that, and the trading venue detects that a firm or a proprietary trader is pursuing that type of strategy, I mean, there should be either, I mean, signing a market making agreement or switching the algo off. That is, let's say, the first step. The second step is the identification of what is a market making strategy. And for that, it is true that we have established a quite demanding threshold. We have considered that if you are performing what we defined as a market making strategy during 30% of the time in one trading day, you should be considered as captured in. The reason we chose that was because, I mean, from the responses to the consultation, it became clear that no matter where we set the threshold, it could be easily gamed. Therefore, I mean, we have made that proposal, but we are open to see, I mean, the views of the respondents, to the attendance to the open hearing and the respondents to the consultation, because we understand that probably that might have to be fine-tuned. Again, in principle, I mean, this requirement should not affect what the firms which are currently performing a market making or liquidity provision, which are currently involved in a liquidity provision scheme or market making scheme. It should be, and it aims at capturing, I mean, other type of firms which are doing this type of certain type of strategies, and they are not subject to any type of agreement or arrangement. So that, I mean, which is clearly in line with the purpose of level 1. Finally, an additional element is the content of the market-making agreement. Here, regarding the content of the market-making agreement, this is something that has to be designed by the trading venue. Again, we can see that there might be let's say, I mean, the current market-making and liquidity provision schemes, in principle, should not be affected. And there would be another group of participants, which are these new market making, and these firms which are pursuing market making strategies, which would be the ones that probably should adapt their strategies and their organizational structure to something more professional so as to meet the requirements. But again, if you read it carefully, I mean, the minimum presence times, for instance, will be 50% of the time, which is very far away from the regular presence time that it is required currently in the liquidity provision schemes, market making agreements. Again, something where we would appreciate, I mean, the contribution from the respondents to the consultation is whether there is, I mean, we should take into account differently equity and non-equity, whether some type of non-equity instrument should require some type of different approach. I mean, this is something we would very much appreciate. Another element which, I mean, apparently has created confusion from the reactions we have had so far is the market-making agreement, which requirements it sets in relation to the different situations. I mean, in which cases a market maker could pull out of the market. And then we have normal circumstances, so normal trading conditions, stressed market conditions, which should be construed literally as what is currently defined as fast market, and it is defined by the trading venues, and exactly as in fast market conditions, I mean, it is the trading venue which defines that. And finally, a third one, which will be exceptional market conditions. In stressed market conditions, aka fast market, what the RTS says is that the trading venue should have a scheme of incentives so as to promote people staying in the market. But I mean, there is no obligation, there is no penalty in case the market maker decides not to be present. And it is important to note that. I mean, the obligation is on the trading venue to have some type of incentive so as to facilitate as much as possible the presence of the market makers in stressed market conditions. And finally, the exceptional circumstances. The difference between where clearly the market makers can pull out of the market without any problem. The difference between these two is that whereas during the time in which a market maker, during stressed market conditions, if a market maker is not in the market, probably is not sending quotes, the difference is that probably that time can be counted in terms of presence. And that, I mean, he cannot get any rebate for that time, as opposed to exceptional circumstances where clearly there is no obligation, so that time doesn't count for the 50% or 75%, depends on the different schemes that different trading venues have. And finally, I mean, there is another element of the market-making schemes where we have not established any type of limit in terms of, I mean, how many market makers can take part in a market making / liquidity provision schemes. But at the same time, we have opened it to competition, leaving it up to the market to determine, I mean, to which extent, I mean, it's necessary, or, I mean, they want to reward only the firms which have shown the best performance or I mean, it is up to the trading venue to determine, in which way they want to reward these market makers, always fulfilling the principle of proportionality, meaning that, there has to be, some type of effective contribution to the liquidity of the market and a certain degree of quality so as to access to that reward. But this is as far as this requirement go. Then again, we are very much aware of how different this requirement from level 1 is from the existing scheme or from the existing market structure, and we would appreciate, any type of comments from the respondents, because we are aware, that this might create some type of frictions that we are trying to avoid as well. So, any comments are welcome. Thank you.
Thanks so much, Alberto. So the RTSs try and specify when a firm pursuing an algorithmic trading strategy is market making, then go on to talk about what obligations the trading venue should impose, and particularly looking at this distinction between normal circumstances, stress circumstances, and exceptional circumstances. And then, as Alberto was saying, we'd be interested particularly in comments, not just around that construct, but whether there needs to be some more variation across asset classes. So yes, please, your hand up was up very quickly in the middle there, please.
Thank you, Brett Chappell from Nordea Investment Management. I just have a query. Is there a definition over for whom market making is? If you are a German mid-sized bank, you will be dealing a lot with retail customers. And there could be people who are doing algorithmic trading that are placing their orders with this mid-sized German bank. At the same time, they would then have a market-making capability for that. However, if you're a large U.S. investment bank, perhaps you're going to have more institutional investors. So I'm wondering, do you have a different definition for the quality of the investor who's eventually going to be protected, whether it's going to be retail or whether it's going to be an institutional? Because that would have a different effect on how a liquidity provider would make markets.
I'll hand over to Alberto in a second, but I think the legislation is constructed in terms of thinking about the trading member's strategy on the trading venue, rather than the trading member's relationship with their clients. But Alberto?
Yeah, in fact, this requirement comes from level 1, and if you look at the recitals in MiFID, apparently the intention is by introducing this new market-making agreements, market-making strategies, and all that, tries probably to smooth events of moments of extreme volatility. So this regulation is not addressed to the type of situation you mentioned, but it's simply addressed to participants in trading venues. We have limited the scope so as to be as clear as possible to trading venues where electronic trading can take place. So, for instance, voice trading systems and all that will be out of the scope.
Other comments and questions on this? You've also come back very, very quiet this afternoon. It's this kind of post-lunch lull, isn't it, while you're kind of working off the enjoyable lunch. So, question here, Michael.
Yeah, thank you, David. Michael Sterzenbach of BWF, which is a German broker-dealer association. I have a few remarks and some questions with respect to Chapter 4.3. Our concern when reading your proposals comes from our members' function as securities firms being mandated by German exchanges for the management of a specific order book in a specific security. In this capability of a comprehensive order book management function, there is a market maker functionality usually in a restricted way compared to a traditional market making environment. So for instance, the self-dealing of these firms are not allowed to be pro-cyclical. Or for instance, the self-dealing of these firms has to step back if there is a counterpart in the market who could also match with a given order, and so far and so on. So just to say, we are talking here about well-established, MiFID I compliant, and also I didn't find anything in MiFID II to say they are not compliant anymore, well-established market models which serve particular investors' needs in particular, but not solely for retail investors. The concerns we have now is that if the rules and regulations proposed for Article 17.3 and 48 with respect to market-making agreements and market-making schemes, if the scope of this application does not have a clear demarcation to existing and compliant, MiFID-compliant market models, and I'm very grateful that Mr. Garcia just mentioned that existing market-making agreements should be untouched by this regulation. In the discussion paper, ESMA also wrote that the purpose, and we fully agree, the purpose of this new regulation is to avoid or to mitigate the risk of potential volatility peaks. And one might add that these peaks or the danger of these peaks may result from de facto market making without having at the same moment an obligation in place to have on a pretendable basis a liquidity provision. But this is not the case for all the different existing market maker systems, arrangement and structures we might have in Germany or we might find in other places across the EU. Unfortunately, the chapter 4.3 does not make sufficiently clear where is the demarcation of this new provision, which is basically intended, as I understood, and I agree with, to cover a so far, let's say, regulatory white spot. This problem has not been addressed so far and is addressed now because we had changes in technology and changes in market structure. In the mandate and also in Article 48, there is an imperative to think about where such schemes with their non-discriminatory access requirement might not be appropriate, and not only in terms of scale of trading, which means to our understanding liquidity, but also to the type and the nature of trading, which to our understanding means market model. And we would be very grateful to further discuss with you and to find a way for a better understanding. And of course, we would like to see some kind of confirmation, just as Mr. Garcia just said, that existing agreements usually should not be affected, that we don't have to worry about whether this new regulation, which is intended, and we agree, to regulate firms which so far have not been regulated, but the effect might not be that firms which always have been regulated and to stricter, more far-reaching requirements than the minimum requirements discussed here, in the future would have been to be afraid that their business model and their market model would not be allowed anymore.
So this is a question about existing arrangements by non-algorithmic
No, I mean,
traders.
the problem with respect to algorithm is, of course, these existing market makers, they today also have an automated trading environment. So they don't have a book, a physical paper book in front of them, making quotes and taking orders. But of course, they receive the orders on an electronic way. And of course, they quote usually by using a quote machine. And the question is whether these specific quote machines could be considered already to be algorithmic trading. But even if they would be considered so, we think that there is a strong imperative in Article 48 2b to say, well, there are cases where the nature of trading, so this is a market model, adjusts that first of all there is no danger. There is no danger that there is some kind of loophole or circumvent or so. Because these arrangements usually go in terms of what they demand, in terms, for instance, in presence time, or the price quality. They go beyond what you request in the minimum requirements. So there is no danger of a loophole. But one must say that these different market-making structures, there is no indication in level 1 that they should not be able to exist in the future. And ESMA is not mandated, as the headline unfortunately suggested, to find a new regulatory framework for market making as such, which is still defined in Article 4 of MiFID and not 73. 73, as ESMA itself did recognize in the discussion paper, only describes a very small typical activity, and it cannot be, these provisions should not be transponded or viewed from other points of market making. Also in the level 1 text there is this recital, for instance, which says, well, firms affected by 17.3 should not be at the same time fall into the same definition as, for instance, with respect to the market-making activity in the short-selling directive. So there's a clear indication in level 1 that this new regulation arising from 73, and in a second step, the schemes to be set up by the venues, which should control and set a framework for this, that this is not a new regulation of market making as such, but it is intended solely to close a gap for those firms de facto acting as market makers, but so far did not have to follow any obligations. But there is no intention to touch or even to prohibit market-making structures and market models which are in place, which are completely compliant with MiFID 1, and so far also we think they are completely compliant with MiFID 2 and with other parts of European regulation. The short-selling directive...
Michael, let's just stop there. I think we got that general point. I want to, before Alberto responds, I just want to say something I mentioned at the beginning of the day. I think it's really important that we don't get up on this platform into trying to opine on the specific circumstances of specific firms or market models, because I don't think that's what we're here to do today, and particularly given that we're on the record, I don't want us to get drawn into making what might be taken as definitive comments about I'm MiFID compliant or I'm not MiFID compliant. So can we just take the generality, Alberto, about where do existing market makers and existing market making arrangements stand in general terms?
First of all, I mean, there are things that I said and there are things that I didn't say. I mean, I did not make a general statement saying that, I mean, all the market making arrangement or liquidity provision schemes out there would not be affected. In principle, I refer to specific circumstances of the RTS. I think this is very important to be clarified. Second element, indeed, there is one provision where, I mean, we say, and we have to say because this is mandated, in which case, I mean, having a market-making scheme is not appropriate. I mean, we're looking forward to hear and to get the description of those other type of trading systems where it might not be appropriate. But again, it might be very useful to have, I mean, a clear definition of exactly the reasons why. I mean, both the description of the functionality of the type of trading, of the business model, trading model, plus which are the reasons for which, I mean, you can say that is critical for the responses to the consultation paper. Thank you. But I mean, there is no opposition because there might be reasons for which it might not be justified. I agree with you. I mean, it's different.
Okay, thanks, Alberto. Andrew, with the blue shirt.
Thank you, David. To the question of asset class differentiation, Alberto, in your introduction, you made a reference to kind of voluntary commercial intent to become a market maker. Would certainly be very concerned that in dealer-driven markets, quote-driven markets, that you could incidentally be caught by the restrictions or the definition of a market maker. I think one day, 30% of the time is very restrictive in those kind of structures. Given the structural parallels, if you like, between a market maker on a venue and a systematic internalizer off a venue, would you consider for areas like fixed income to compare the validation period, this kind of 3-monthly, quarterly assessment, 6-month look back, in order to better differentiate between incidental triggering of the market maker conditions versus a consistent intent to be so?
Okay, let's just collect any more comments and questions on the market making set before Alberto responds. One down at the front here.
Thank you very much. I just want to pick up on the point around market arrangements and OTC and low volume markets more generally. I think the way that we looked at the the thresholds didn't really work very well for certain market segments, thinking in particular of interest rate derivative markets. If an order goes in the morning, you might reprice that during the day, and you might show both sides in order to not show your trading interest. That same order looking for a trade might be captured by the 30% because it doesn't get executed until the end of the day. So you'd be very concerned if that would mean that anyone who has a pricing engine, which means he qualifies as an algo, would suddenly be caught up in the market-making arrangements as well. So we're wondering whether there's any flexibility for the venue to kind of determine whether someone is genuinely pursuing a trade or whether he's generally pursuing a market-making strategy more widely. So we think it's quite important that there's that flexibility. Thank you.
Thank you. Any other questions on market making before we look to Alberto to wrap up? Okay, Alberto, concluding comments, please.
Very quickly, I mean, in relation to, we are clearly open to reconsider the thresholds and the date, how many, and the observation period. That's why we have consulted, clearly. And clearly we can look at the systematic internalizer. However, I think that looking at the 6-month period in something that, where, so many trades can happen in a second, I don't know, there might be some type of, but indeed, we're gonna, clearly this is one of the proposals that we were aware that, it might imply a change. So, this is one thing in which we are specifically consulting. So, the second element is about the point that you made about the interest rate the market. To be clear, we're talking about two-way quotes. So, if it exists and all that, again, it comes back to the same point. There might be cases and there might be markets in which, the same might not be applicable. So, again, exactly your point, if it could come in bright, then it would be very much appreciated.
Okay, thanks, Alberto. We're going to move to another topic now. This is probably a good moment for those people who are standing at the back to come and find a seat if they'd like to, ahead of the next section. What do you want to take next? Tick sizes? We're going to take order to trade ratios next. Alberto.
Thank you, David. In relation to order to trade ratio, again, we have another element where, what we are trying to is to set out the methodology to calculate the number of orders that can be submitted by a member or participant to a trading venue. And there, our methodology is based on the volume of orders and the number of orders. That calculation has to be made taking into account the previous year's orders and transactions and took place during the previous year. The proposal includes certain elements of flexibility, which is that the trading venue can group or the financial instruments as they can pick up more or less granular approaches. as they see appropriate according to the type of trading model that they have. And the new trading venues can use projections because, of course, they didn't have any figures to work on. However, the outstanding question is whether some additional elements of flexibility should be added to this, because if you remember the original proposal, the discussion paper was based on the introduction of introducing a type of multiplier. So, and now, probably, that is the question. Whether you consider the methodology is correct, whether some more leeway should be left to trading venues, or so again, any views are welcome. Thank you.
Thanks very much indeed, Alberto. So we put a relatively modest proposal on the table around what methodologies trading venues should use to calculate maximum order to trade ratios. We are not directly specifying what those maxima should be, but just looking at the methodology which should be used. Any comments on that particular element? Yes, please, in the corner. Keep your hand up and the microphone will come and find you. That's it.
Oliver Robinson from ESMA. I suppose our comments are based upon or take into account what the consequences of being in breach of the maximum OTR would be. I know the Commission suggested against providing for particular penalties, but in terms of the measurement, I think we had concerns that the measurement period, in a similar way to the market making, is based on 1 day's activity when the actual threshold is set for activities over a whole year. So whether or not particularly stress conditions on that day, which would require a particularly higher level of cancellations or result in a particularly higher level of cancellations, could be create false positive readings. And also the potential for a de minimis threshold to be put in place, to bearing in mind the objective of the maximum OTR to try and avoid unnecessary systems usage. So if a particular participant has a very low volume of trades, it may well be the case that they'll cancel them, but they wouldn't have a series of filled trades to then cancel out their average number of fills. So in that sense, it would be beneficial, bearing in mind the fact they would have very little impact on the capacity of the particular venue.
Okay, thank you. Any other questions or comments on order-to-trade ratios? Okay, well, perhaps you might wrap up any concluding comments on that with your introduction to the next section, which would be co-location and maybe fee. Let's take co-location and fee structures as one piece.
Thank you. Again, co-location and fee structures, I mean, the elements that we have to define is that they are fair, non-discriminatory, and here the approach that we have taken is very similar to the one that appears on Article 37, I think, of MiFIR, on which, I mean, trading venues, because at the end of the day, it's just a matter of fees on both cases, let's say. And on who do you want to grant access to your premises is, we admit the trading venues might determine, according to their own commercial policy, determine, which type of access and which are the fees that they want to charge to different type of users, and then, different prices can be charged on the basis of non-discriminatory and unpublished commercial grounds, such as the quantity, scope, or field of the use demanded. So, again, this is an element, which is kind of tricky, because, we are not trying to prescribe any type of fee structure or anything, and we have identified as well, certain one type of fee structure that we consider that can contribute to disorderly trading conditions, which is the cliff edge. And in relation to co-location, we basically proposing, having additional publicity and having as much publicity, and we describe what should be considered as non-discriminatory practice in that regard. We have also asked, and I think it is important to highlight here, that in the body of the consultation paper, we have asked specifically, questions about, potential fee structures that might contribute to market abuse, because there were some vague indications in the responses to the discussion paper. So again, any type of indication to refine in relation to the fee structures that might contribute either to disorderly trading conditions or to market abuse are absolutely welcome. Thank you.
Thank you, Alberto. So again, I think relatively straightforward proposals around how trading venues should look at co-location services and their fee structures. Transparency and non-discrimination, I guess, are the main principles that we're bringing to bear here. Does anybody have any comments or questions on that segment of the CP? No? Okay. Well, that takes us on to tick sizes then. Alberto, tick sizes.
Again, tick sizes, as you all know, probably is one of the most relevant proposals that contains a discussion paper where, clearly, there has been a mandate in level 1 to determine by the regulators, which is the appropriate tick sizes, and there we have made a proposal with respect to equity and equity-like instruments, whereby, we have 5 tables for shares deposited receipts and the certificates. They are based on the average number of transactions and during the previous year and the price of the instrument, which should evolve along the year. And also we have a specific proposal for ETFs, whereby, ETFs will always be allocated the tick size corresponding to the most liquid band. At the moment, let's say, the core discussion and probably what we should have here is, even though probably is not here is not the right environment because it's such a technical issue that probably, I mean, what the element here is the discussion is about the distribution of the different bands in terms of, I mean, the price of the average number of trades, whether you consider that the allocation is correct, and whether the tick size, the actual tick sizes on each bucket, I mean, are correct or should create some type of damaging effect. I mean, as I said, I mean, comments are absolutely welcome, but I mean, probably I would encourage you, if you have any points about this, I mean, to submit, I mean, written answers to the consultation paper, because in this case they will be critical, and of course, I mean, the RTS is not closed. There is a second element of the RTS where we can also discuss, which are additional elements in terms of procedure, which is mainly that the average number of transactions should be determined by the most liquid market in terms of liquidity, and also the elements of flexibility that the RTS proposes in terms of the possibility of corporate actions so as to reallocate the tick size in case it is obviously wrong, or the possibility of the trading venues to use their expert judgments for new issuances. But again, I mean, given the difficulty of the topic, I mean, both comments here and in particular in Britain to the consultation are absolutely welcome. Thank you.
Thank you, Alberto. So this is RTS 18, and particularly interested in views about the methodology that we are adopting, as well as the outputs of the methodology, in other words, the resultant tick sizes that emerge. Clearly, if we are going to propose a more harmonised tick regime across Europe for equities, it will imply some changes for at least some instruments on some venues compared with where we are today. And so it's important that people understand the implications of the proposals we've put out there and reflect back to us whether they think it produces a sensible set of outcomes. Any comments or questions now on that point? Yes, please, over in the corner.
Thanks. In regards to tick sizes for ETFs in particular, we think that as ESMA's new table is a very good improvement from the previous work in the discussion paper, and think that this is a very good starting point for ETFs. The concern that still remains, however, is that, one, given that there's no trading obligation for ETFs, and so therefore there's no obligation for ETFs to trade on a lit venue, any tick size regime for ETFs that lacks flexibility or the granularity that takes into consideration the one could call it the almost super liquidity, as it were, of ETFs would almost lend itself to ETFs trading away from lit venues, and we don't think that would be a good thing for the ETF market. A possible solution could be a separate tick size table, particularly for ETFs, or an alternative, perhaps some sort of exceptions process where for what we'd call for super liquid ETFs that consistently meet a certain tick size threshold, they be accepted from the sort of non-granular approach in the current tick size table, and this exception process could be run by perhaps the ETF issuers, registered market makers, and the exchanges.
Sorry, before we are talking about a specific tick size regime for ETFs that would be more, I mean, so which would need a smaller tick size than Vodafone shares.
Yes.
Any other comments or questions on tick sizes? At the front here, please.
Frédéric Monpère Amundi. I'm also putting some comment on the ETF tick size. First, to underline that we are quite in agreement with the fact that price range is the proper approach. and that the liquidity band, there shouldn't be different regimes according to liquidity, because we do not understand what liquidity means for ETFs. So it's quite good that we are on the second point, that we totally agree to be on the far right of the table, meaning highly liquid. I would just put two more comments. One is to say there must be some device in order to avoid to have discrepancies within the same day, intraday, if we changed range in the middle of the day and then get back to the other price range, how shall we be able to cope with that? The second point is actually, yes, we think that tick size is so important for the liquidity of ETFs and for the bid and offer spread that we could be a little bit more aggressive and have smaller tick sizes.
Okay, thank you. And a question over there, Nick.
Yeah, Nick Dutton, that's Chi-X. The one point we want to make here is in the calculation of liquidity for tick sizes. There are plenty of places in level 1 text where they mandate use of most relevant market in terms of liquidity. Tick sizes isn't one of them. I mean, ESMA cites ease of implementation for just using the primary market's volume. But this leads to, certainly for very liquid shares that are traded across multiple venues, this can lead to a widening of ticks. I think the UK market, but also the German market, would be particularly hit by this. I think ease of implementation isn't a very good reason, given that national competent authorities and ESMA will have the volume data from all venues. And as I said, it will lead to a widening of tick in a lot of the very liquid stocks. The implications of that being, if you constrain the spread, then you no longer get price competition at the bid and offer, and it becomes a straight speed race. So you're actually advantaging the lowest latency players.
If we, just to finish that point then, Nick, if we had an approach in which volume across more than one venue was used, how would you envisage the calculation being done? Who would do it?
The National Competent Authority, or ESMA.
Okay, thank you. Any final comments on tick sizes before I get Alberto to respond? Yes, please, at the front here. Just put your hand up again, that's it. Thank you.
Christer Wennerberg, SEB. I think, first of all, I think the amended model is much better than the previous ones. But I think one should be very careful reducing the tick size, because too small tick size will reduce the liquidity in the order book. So I think that in the text you can read that one should be based on FESE 2. It's a quite sensible model, and be very, very careful to reduce tick size for equities. Thank you.
Okay, thank you. And then at the back on the left, thank you.
Yeah, my name is Sandra Bramov, Deutsche Börse Group. I have got one comment on the ETFs. I would agree with the ETF issues here that the proposal so far is quite good, but I think for some of the ETFs we would need an exemption process. And in our response we have made some concrete proposals how that could look like. And regarding shares, I've got a question. ESMA suggests to set the floor at 1.5. I think you can have a debate about this, if this is good or not. But my point here is, if the floor is going to be set at 1.5, for quite a substantial number of our shares, that floor isn't even being met. So it's below 1.5. And that is quite worrying for us, because this is a benchmark suggested by ESMA. And then if you take into account what has been suggested in the market making, this is Article 1, number 7 of RTS 15. There you have the requirement for market makers to quote competitive prices. And these competitive prices are based on that you have to do that within the bid-ask spread. And that might be quite complicated and very difficult to achieve if the spread-to-tick ratio is 1.5. First of all, but secondly also if 1.5 is actually even lower. So basically you have zero leeway in the spread. So the question here is if that is something that ESMA could have a look again at to see if something could be adjusted here.
Okay, thank you very much. And thank you for mentioning that you're developing a response to the CP. It just gives me a chance to remind everybody that the main CP closes for consultation on the 2nd of March. And it's been good to hear a number of people in the audience already referring to concrete responses that they have been drafting. So it's good to know that we can anticipate at least some responses to the CP. But 2nd of March is the date to aim for. The supplementary CP closes on the 20th of March, I think, the one that was published yesterday. Okay, Alberto, do you want to wrap up on tick sizes?
Very quickly, I mean, regarding the need, the comments from IMA and Deutsche Börse about, I mean, the need for some type of exemption process or even smaller tick size. I think that, I mean, we're happy to receive any comments in this regard, but again, probably, and given that ESMA has provided all the information regarding, I think that, we've never been so transparent, and by far, we've been extraordinarily transparent in relation to the way in which, we have developed the tables and where each figure comes from. What we appreciate in particular is that, and given that we have created specifically an exemption for ETFs, we would appreciate as well, a contribution in terms of how would you refine the system rather than creating exemptions or waivers or something that gives away. Because I think that probably that might not be feasible within the level 1 mandate. So again, you can submit whatever you want, but that probably, some type of, specification on how would you refine the system would be welcome as well. In relation to the capacity of ETFs to change intraday, I am afraid that, at the moment, they are evolving intraday nowadays, so I really don't see which is the difference here. I don't see. Regarding that, all trading should be considered. It is technically feasible, but regarding the feasibility, I really believe that it will be very, very, very complicated. From a feasibility, it's true it is feasible, but it might be quite complicated. Regarding the reduction of tick sizes, well, we have heard all sort of, it's true that, there are opposing views also between the academics, so we are still analyzing exactly which is the right spread to tick ratio and how to refine the table. So again, we are open to all contributions. And as I said, regarding the point about, the potential contradiction between, the tick size and the market making obligation, this is a point we're particularly interested. So yeah, we will definitely take that into account. Absolutely. Thank you.
Okay, thank you very much. We're going to move next to talk about a raft of commodity derivatives issues, and Catherine Sutcliffe is going to come up and join us for that. But we're running slightly ahead of time, so let me just pause and see whether there are any other areas or points that we haven't talked about so far and which aren't commodity derivatives in the market space, which people just want to flag for our attention, things that that you're concerned that we just need to be aware of, or particular concerns that you have. Just open floor for other points. Arjun.
Thanks. In regards to definition of liquidity for shares, if we could go back to equities for a second, and apologies about this. The ESMA proposal around most relevant market for the purposes of determining liquidity for equities, the proposal to scope out those transactions that have been executed under the waivers. I just wondered if you could comment on why you've opted to do so, why you've opted to do that. In our view, we think that all equity transactions, including those that have been executed under the waivers, ought to be counted towards the determination of the most relevant market for the purposes of liquidity. That would give you a truer sense of liquidity for equities, as opposed to almost artificially scoping out those transactions that have taken place under the waiver, under the waivers. And plus, transactions that have taken place under the waivers, at least on a post-trade basis, do contribute price formation information and price and discovery information. And so, just wondered if you could comment on why the exception has been made.
So I think in a way you've answered your own question. This is clearly not an absolute hard and fast approach. You could easily take the approach that you've just outlined. I think in the proposal that we put forward, we were very much thinking that the trades that were transparent on a pre-trade basis were more centrally contributing to price formation, and therefore particularly in defining the venue which could form a reference price. That was the approach to go for in that context. But I think I agree with you. It's not an open and shut argument. Any other points? Yes, please, in the front row. As I say, we're going to come on to commodity derivatives shortly, but I'm just keen to make sure that you get your money's worth from having come to Paris in terms of being able to register points with us.
Hello, Miranda Morad from Market Access. A quick question in relation to RTS 14. I wondered whether or not it was the intention of ESMA to address or not to address whether or not RTS 14 is intended to apply to RFQ and voice. The reason I ask is because in the CP in the summer there was a sentence that suggested that ESMA thought the mischiefs that it was intended to address wouldn't be applicable to RFQ and voice, but I can't tell where ESMA stands on that now.
You've got everybody on the table looking to remind themselves what RTS 14 is. Alberto is the expert. Well done.
In relation to this, I mean, it is true that, I mean, pure voice systems, I mean, they would not make sense to be within the scope. I mean, the formulation that we have chosen is slightly more open. We say that that the RTS affects, I mean, trading venues where electronic trading electronic trading venues through which, I mean, electronic trading can take place, therefore. I mean, if we are talking about let's say, a totally electronic interaction, I mean, they might be subject to part of them. And in fact, I mean, I revert to what we said in the discussion paper, where, I mean, we might have different, let's say, it might be a system where certain requirements could be applied to investment firms, a different set of requirements could be applied to trading venues. So in terms of trading venues, a voice trading system, I would say no. An electronic request for quote system, if we're talking about the trading venue, I would say yes. A request for quote system from an investment firm, yes. If it is purely electronic, insist. Okay.
Question at the back, right at the back.
Bernard Aguilon from Amundi. I would have a general comment on the problem of market making. Behind the question of colocation and the question of tick size, there is a problem of high-frequency trading. It is not possible to make high-frequency trading on securities which are not already very liquid. And in fact, everybody admit that the liquidity which is provided through high-frequency trading, it is sort of exceeding liquidity, but not a necessary liquidity. And in the buy side, about the buy side actors, many buy side actors consider that high-frequency trading is sort of a parasite activity, and we've been a little bit deceived by the content of the 11.1 and level 2 provisions, as well in ESMA CP, on this problem of high frequency trading, which entail technical problem, because we could have major accident on the technical functionment of markets. And there is another problem, which is the cost of controlling high frequency trading. It is a cost for regulators, and this cost is supported by all actors who contribute to the function of the regulators. Thank you.
Okay, thank you. Any other comments before we move on to commodity derivatives? Right at the front.
Alex from WNBA again. Alberto, just to pick up from Miranda's point, would I be right to say that all of the DEA provisions, the direct electronic access, would not apply to OTFs because OTFs have to have discretion? Can we say that now or not? Because you cannot have direct electronic access with discretion.
And I'm very keen not to make any definitive statements from the platform at all today. Especially that one, says Rodrigo. Let's move to commodity derivatives then. I think this will also be a lively discussion. Catherine is going to come and join us. Thank you very much, Alberto. We've got three broad topics on commodity derivatives. The first is defining what it means to be conducting ancillary activities such that you don't require a MiFID investment firm authorization. Second, we've got some proposals around how the position limit regime will work. And then thirdly, actually a relatively limited set of proposals around how the position reporting regime will work. Actually, our empowerments in that space are relatively tightly defined, and we're largely talking about formats for reports rather than the whole position reporting scheme. So let's start with ancillary activity, and we have tried to respond to the comments we had on the discussion paper, which said, can you try and make the way that you do the calculations for this a little bit simpler? So we've tried to respond to that, and Catherine will lead us through it.
Thank you, David. And good afternoon. Okay. No? Okay. Oh, that's better, yeah. So good afternoon. So going through the ancillary activity, it's one which has garnered a lot of attention because for those who are concerned with it, it could mean a substantial change. So those who are aware of this will know that at the moment under MiFID 1, you have an exemption under 2.1i for commodity traders, and that this is being narrowed significantly at level 1 under MiFID 2. So there's already a narrowing there. And then in addition, at level 2, ESMA's mandate is to set the thresholds. So whereas today there's no level 2 rules, there's no quantitative criteria, this is what we are mandated to set. And of course the big debate is, where are those levels? So what we propose in our CP, and this is in the draft Regulatory Technical Standards 28 and section 7.1 of the consultation paper, we propose two tests. So the first one is about capital employed, and the question there is, what percentage of your overall capital on a global basis do you employ for MiFID II activities, i.e. activities which you would have to be normally authorised for MiFID if you weren't exempt? And we've put there a threshold of 5%. We say to do this calculation, use the accounting definition of capital. We're already aware that this is difficult for some firms. You don't disaggregate or disentangle on that basis at the moment, so we need to think about proxies and get more information on that. But that's test one. And then the second test is about trading activity, and there the question is, what percentage of your EU trading in an asset class do you have of the market? So what's your overall percentage level of the EU market in volume for a commodity asset class? We set the percentage there at 0.5% of an asset class, and we've set 8 asset classes. So metal, gas, power, agriculture, coal, oil, emission allowances, and other. And in other, we've thrown freight. And the approach is if you're above the capital employed, so you're above 5%, you're in MiFID, or if you are above 0.5%, you're in MiFID. So it's not both, it's one or the other. We've had feedback, particularly on the trading activity. So the key question people need to know there is, what's the denominator? What is the size of the EU market that we need to measure this against? And we're going to do some data analysis on this. Rodrigo mentioned at the start, we are doing a cost-benefit analysis and data collection, and that will be part of this approach to try and size the market there. We've also heard from various parties this 0.5% is low, and there it's important to make the point that when firms do these 2 calculations, they don't include hedging activity, and there we say follow the EMEA definition. They don't include intergroup transactions, and again, follow the EMEA, and any liquidity obligations, you don't include those either. Then we have also, the scope of firms which are falling under this, goes from farmers to multinational energy firms. And we wanted to try and minimize the burden on particularly small players. So we don't have under the level 1 the right to waive a notification process. But what we have put in is a de minimis, which is if you do the trading activity test and you're 0.25%, in each asset class, you don't have to do the capital employed. You would, though, still have to do the annual notification to your national competent authority to say, I'm using the exemption. There's no level 1 mandate to waive that notification requirement. And that's the purpose of these calculations, is to determine if you're below or above the threshold, and if you're below, then you do your notification annually to the competent authority. In terms of doing these calculations, we've said it should be done on a 3-year average rolling basis. We have been asked for transitions. That's not level 1, so it will start on the 3rd of January. And we said for the first year, we'll do it based on 12 months for 2016. And again, feedback there was, there's no way from the 31st of December to the 3rd of January, we're going to be able to do that calculation and become authorised. So we will take that away and realise that provision is not the one that we will need to work on. So those are that's the key framework we've proposed in our consultation paper in RTS about ancillary activity. So then hand it back, David, to you for comments and questions.
Thanks very much, Catherine. So I should have said this is draft RTS number 28, and it's section 7.1 of the CP. And a bit like our discussion this morning about non-equity transparency, this is an area where we are at one and the same time designing the methodology and calibrating it. So there are a lot of moving parts. And as Catherine describes, what we are trying to put on the table is something that we think aligns with the intention of the legislators, which is to try and capture actors who are either have a large proportion in Europe of their group activity doing commodity derivatives trading over and above what would be, in a sense, the normal course of business, what in the CP we call the privileged transaction. So that's an important point to bear in mind. This is only capturing, the tests are only capturing what you might call, in inverted commas, speculative activity. I don't like that term myself, but I think it's commonly used in the debate. So that's the first test, or that you are, again, with your speculative activity, a significantly large part of the European trading landscape. So that's the conceptual idea. And then the questions are whether that methodology is workable, and then secondly, whether the calibration is right, recognising that given that this is currently exempt business, we don't have a readily available data set yet to be able to test the calibration, although it is one of the key focal points of the next phase of the CBA that Rodrigo was describing this morning. So let's stop there and get some comments and questions. Who would like to start? Yes, Carl Peter.
Thank you very much, David. It's Carl Peter from EFID, European Organization of Energy Traders. We appreciate very much the difficulties you have with the calibration of the system. And I think we as an association and the firms would be happily supporting you with concrete data to calibrate the system further. We have done such a preliminary work within our association already. We have done a first impact assessment. The feedback of our members is such that, as currently calibrated, no firm sees that it can make use of this exemption at all. That means, stemming from that consequences, there are severe cost impacts on the wider economic system, which we started to calculate. We have done that quantitative impact assessment, and it gives an order of magnitude where we come out with an important 2-digit billion figure to the entire economy, consumers, and industry. And one example there I would like to highlight now, and we will share that impact assessment with you in a couple of days, is that we think your proposal forces people out of a business or into a MiFID license, with the result that in the end the liquidity in the whole system will be substantially, dramatically reduced. And one of the effects of reduced liquidity is much widened spreads. Yeah? The bid-offer spreads are much more widened, and commonly known this leads to higher costs. We have calculated that cost. That cost amounts roughly, and this is a careful first indication, to 4 billion for the energy derivatives in Europe, which would transfer to an increase of a household bill to 20 euros per household. This is only one figure. We have done calculation for other bits and bytes. In the end, we come to a conclusion that the purpose of the regulation, or of MiFID II and the implementing regulation, is definitely not, in our opinion, to restructure an entire market with the end result that the competitiveness of Europe, its industry, and the cost to consumers are substantially decreased, so decreased competitiveness worldwide of Europe, and substantial decrease of a consumer bill or the energy bill to the industry and the consumers. Therefore, we would really call for a really serious cost impact analysis, cost benefit analysis, and we are more than happy to support that process. Thank you.
Thanks, Carl Peter. Just before you hand back the microphone, we'd be very keen to see, obviously, the analysis you've been describing. Is it the conclusion of your analysis that the fundamental approach is wrong, or that the calibration is just misjudged?
We believe that ESMA has taken into account a lot of the well-founded proposals as regards methodology. I think there has been a lot of improvement done, and the travel of direction is not bad, although there are many comments to make, and I don't want to monopolize the discussion now today. I think others will make those comments as regards methodology. One important point is that what Catherine mentioned, the 2016 test, which does not work. That's one very important point. But we think about the calibration now. What I'm talking about is the calibration. Yeah? And the calibration, we think, to put it straight, it's not appropriate for the time being. Yeah? And I think we need a serious cost-benefit analysis and data analysis to avoid any adverse unintended consequences on the competitiveness of Europe and on the energy bills of consumers. Yeah? Thank you.
Great, thank you. Other comments, please. It's over on the right there.
Jeremy Penn from the Baltic Exchange. Our concern is with the shipping market, the freight derivatives market. We're very worried by the way in which, as Catherine puts it, freight was thrown into this revitalized C10 definition drawn from MiFID I. we've been struggling over the last couple of weeks to actually calculate the size of that overall market segment as it's currently defined. But your document last night, I think, puts freight at 57% of that market segment. So a very large proportion of it. We don't think that pretty much any of our market participants will be able to use the hedging exemption because of the portfolio nature of the way in which they use the instruments. So the upshot of that is that with perhaps as few as 200 or so regular market participants in the freight derivatives market, anything up to about 30% of them would become financial entities for the purposes of MiFID II. You would also find that ship owners who were making light use of derivatives to cover their very real risks in the real economy would transgress the 5% capital threshold as well as the 0.5% threshold for market volumes. So the question that we have really, I think, is one of intention. We've racked our brains as to how better we could propose for you that the regulation might be written or the rulemaking might be conducted. And so our question is, what is your intent? Because at the moment, significant numbers of not only ship owners but also commodity firms will fall into the financial entity categorization simply because of their freight trading activity, which is, after all, entirely ancillary to the activity of commodity trading or commodity movement. So my question is, help us to understand who you really want to turn into a financial entity because of their freight trading activity, and then we can help you to define it.
Thank you. That's a good point. I think you raised an interesting point in the question around the interplay between the hedging exemption and how that is defined and the ancillary test. Let's say it's clearly the intention of our proposals to give effect to the level 1 legislation, but in that context to make sure that we aim to deliver the level 1 goals of capturing activity that looks like investment firm activity, kind of over and above everyday business, if you like. Lots more questions and comments on this, so let's go to this side and then we'll come back to Catherine for some comment in a second.
Good afternoon, Stefan Feuchtinger from the International Emissions Trading Association. I want to add a point of calibration concerning the hedging activity exemption, which is basically not yet, it seems, calibrated to the emissions market, because in the EU ETS, you do not have to hedge. What you have to do is comply with the provisions of the EU ETS. So by nature, you are not exempted by the hedging exemption. So we think that this needs to be calibrated. Secondly, the exemption under Article 2, Paragraph 1e. As we know, there are 90 to 95% of trading in EUAs is done on the derivative market. And as you mentioned yesterday in your addendum to the paper, out of those 95%, 95% are done on forwards. Now it's in the nature of the emissions market that on April 30th of each year, emission allowance have to be surrendered, which means that basically the future market is a very important market. Now we think that the way Article E should be understood is to include also forwards and derivatives and not to exclude them. Otherwise, the exemptions that the legislator created in level 1 would basically not make sense anymore. And finally, about thresholds, but I will leave that to the floor. Our members believe that the thresholds as they stand now, they are way too low to be adapted to the emissions market.
I mean, just as a general point, and this, I mean, Jeremy asked specifically about freight, but as a general point, Well, it just does seem to us that it is the intention of the legislators to have a tighter exemption under MiFID II compared with MiFID I. And it seems to me that one natural corollary of that is that at least some activity or some firms who are currently not caught by MiFID I would be caught by MiFID II. It does seem to be an outcome which the legislators intended. More comments and questions, please. So in the middle of the front row here. Oh, sorry, not the very front row, but the middle of the front block.
Joost Mulder, Finance Watch. I thought I'd sit conveniently in the middle here. I wanted to raise a few points on the calculation of the ancillary activity, both on the denominator as well as on the numerator. And I'll start on the numerator. As Catherine said, that is supposed to be a threshold. And in my view, a threshold is something that once you go over it, all your activity is covered. If you would be allowed to do a certain activity and then that activity would be exempt and the rest of the activity would be covered, then I would call that an allowance and not a threshold. What I see in the definition as ESMA proposes could work in practice as an allowance because of the way that the privileged activity in a way can be deducted from the calculation in the numerator. What you could do essentially as a firm is structure the allowance in a part of the business that would then be MiFID compliant, subject to MiFID, and would be considered as an allowance, leaving the rest of the business outside, and therefore de facto you would have transformed your threshold into an allowance. To give an example, you could make sure that just under 5% in the current thinking of market activity is outside of the subsidiary, and accept that your privileged transactions plus the non-privileged market activity above 5% would be subject to the rules inside the MiFID subsidiary. On the denominator, we continue to have issues, and we raised this in a discussion paper with the inclusion of global positions. And I would have a question there. Would that mean, as it's currently drafted, that's a large non-EU domiciled operator, can think of some commodities houses outside of the EU in Singapore or whatever jurisdiction, with a significant impact on EU markets, it could be a market activity of 10, 20, 30%, could be exempt from the ancillary test and therefore not even perform the trading activity test. I also wanted to challenge the rhetoric behind introducing the de minimis threshold. We actually disagree with ESMA that the level 1 text gives ESMA that possibility, and we will elaborate more in writing. I just wanted to refer to recital 20, which clearly requires the criteria that they must ensure that non-financial firms dealing in financial instruments in a disproportionate manner compared with the level of investment in the main business are covered by the scope of this directive. And in our view, that means that you cannot do it any other way than by applying the ancillary activity first before you actually look at the trading activity test. And then finally on the transition mechanism, on the we agree with the need to have transition measures. Obviously, the example you mentioned of 4 days doesn't work in practice. However, there again a question, what would happen if, say, we have a hedge fund with 2 years of business outside of the EU and then moves it into EU commodities trading? Would that player be exempt from the rules for 1 or 2 years in the way that you use a 3-year rolling average? Again, this is not about the transition period up to 2019, 2020. That's it.
Good, thank you. Some very, very pertinent questions. Let's just pause for a moment. We'll come back for some more questions in a second, but give Catherine a chance to pick up any particular points that that she's able. I mean, this general question about Europe versus global is a tricky one because you can think about difficulties both ways. A business that's big globally but small in Europe versus the other way around, and how do you try and calibrate your approach to try and capture the right bit? And what we are, I think, trying to do in our approach is to say what really matters is the proportion that happens within Europe, because that is what would be regulated if you were an investment firm. So we're trying to frame the tests to try and see how big the proportion is that's in Europe relative to your total business or relative to European trading. Trying to come at it both ways. Catherine.
Yeah, so I'll go backwards with the questions and thoughts I've had on them so far. In terms of the threshold being an allowance rather than actually bringing you in, I mean, this is on a group basis, so they have to look at the entirety of their outside. If they have a MiFID subsidiary, this is our proposal, take that out of consideration. Everything else, they have to look at how much capital and trading activity they're doing and then take away the privileged exemptions, and that's on a group basis. So I didn't quite see how they then could circumvent it in the way you described. In terms of not liking the denominator being global, that always comes down to where we draw the parameter, and I think this is something we haven't done yet and we need to do, of what we mean by EU trading, what's in and what's out, that's not clear. But certainly in terms of extraterritoriality, to look at what a firm is doing outside the EU, that would be very difficult. I don't know if we will do this, but when you said that, what struck me was under EMEA and for the trading obligation, we have this idea of derivatives which may have a direct and foreseeable impact in the EU. So it's possibly, at the moment, I don't quite see how we would fit that in, but it's there is that concept there about if you do trading in a third country and it falls in. The de minimis threshold, I mean, it's all subject to more data collection, etc. But really, there we are thinking you can have firms, you can have farmers, for example, doing 2 or 3 hedges a year on a small scale, and they fall in this regime. So there's also, I think, we look at a question of proportionality there. And as for the transition mechanism, you're out 2 years, you're in the 3rd year, you would average that out on a 3-year basis, so you would be out for 2 years. Then if you look across 3 years and you're above the threshold, on an average, as we've proposed at the moment, you would be in, and you keep doing that on a rolling basis. So those were my thoughts on those pretty detailed questions. Going back to the ones about freight and also the remarks made that this could be a real challenge for the energy markets and harm the economy. It goes back to what David said, which is really what we're trying to capture here is, in inverted commas, speculative activity. And to have 0.5% of a market in one asset class with all the exemptions seemed to us the starting point reasonably sizable. If the hedging exemptions are not quite right, which I think was the point made by Baltics, then that's perhaps something to look at if they're not catching commercial activity and activity which is needed to risk manage the business. But then the other side is, are firms saying that if they can't have this speculative activity, it's going to harm them? And that's what I would like to know more about. Is it a case of the hedging exemptions that don't work, or is it a case of you do trading activity, which is pretty much analogous to what investment firms are doing, and without that, without the profits from that, it's going to harm your business. And then that becomes a different question, because we are trying to capture that investment activity. And then finally, on the emission allowance, I think the point there was about the fact there is no exemption really for the compliance activity in relation to emission allowance. It's not built into the ancillary activity exemption. It's something we will look into a bit further. I think another point to just mention at this stage is we say 0.5 for each asset class. Whether in the final result we have the same threshold per asset class, whether we need to adjust them differently for each asset class, that is something that's still open for debate. So those are my thoughts and the questions. Thank you.
Carsten would like to add a couple more as well, and then I'll come back with some more questions.
Just on the emission allowance point, the 2 things you were mentioning, I have to say, those are not calibrations on level 2, those are changes to the level 1 text, and that's what we cannot do. That goes for the scope of application of the E exemption, as well as, a separate exemption for compliance activity. And just in general, of course, I mean, for me, the purpose of this is as well that those who do significant activity in commodity derivatives are regulated like an investment firm to thereby create a level playing field in Europe because of the application of financial regulation and that way increase competition. Investment firms are normally agreeing with this point behind closed doors. In the public, they're normally very quiet then about this point, unfortunately.
Does anybody want to take that implied offer from Carsten? I suspect Mark doesn't want to do that. Mark, in this corner here.
Thanks, David. Mark Cornelius, Shell Trading. 2 points really probably for Catherine. The first is regarding why ESMA chose to depart from the test for both limbs of the test to choose the group activity in the numerator rather than the person, given that the exemption relates solely to the person. Now, interestingly, in the consultation paper, your text expressly says in the narrative that it's the capital employed by the person. In the RTS, it relates to the group. I'd be interested to know thoughts on that. That's the first point. The second one relates to something you mentioned earlier around the ancillary, the minority of activities test that the level 1 explicitly says that is not sufficient. So if you satisfy that as a firm, so if you're under the threshold, that's not sufficient to demonstrate that you're exempt. Yet ESMA is seeking to saying, well, actually, if you breach that, you are exempt. So the burden of proof seems to be skewed very much in favour of regulators. So it shouldn't be necessary, to establish that you are exempt. You've got to meet both tests. But actually, to establish that you're in scope, you've only got to meet you've only got to demonstrate that we meet one test. So if Shell Trading met the size of trading activity test, but didn't meet the capital employed test, we would be regulated. That's our understanding. That seems a bit disproportionate from my perspective. I'd be interested in your comments on that.
Who wants to pick that up? I mean, it seems to us, I think, that is our interpretation of the level 1 text. But Catherine, I don't know if you had any...
Yeah, well, on the group and person, I don't have it in front, but I think you're right, it refers to the person, but then I think it says something along the lines of, you have to look at this on a group basis too. So in our consultation, our discussion paper in May, we had a number of different calculations. We broke it down. You do it on a person level, terms on trading on your own account, then you do it on the investment services, and then do it on a group basis, which seemed complex. And also, basically, if you ended up passing the threshold on a group basis, then you didn't need to do it on a person basis. So that's really why we took that approach, because at some point a calculation on group basis would need to be done, and we think that's in the level 1. And then with respect to the tests and burden and proof, I think, as David said, we think it's appropriate that if you pass one test, you are in, and that's our reading of the level 1.
Other comments and questions on this? Jeremy again.
Yeah, if I could just come back to Catherine, I welcome the idea that you'd be willing to look again at the definitions around the hedging exemption, because that is at the heart of the problem. I think that the way the freight derivatives market works and the product that it offers, it doesn't typically qualify as hedging under the tight rules. So a redefinition of that would certainly help. But I would also like to emphasize the very, very skewed nature of the categorizations, in the sense that the tiny freight derivatives market constitutes 57% of one category. That compares with oil or metals, to include all of presumably iron ore and coking coal, as another category. So it is utterly disproportionate that people should be tripped into becoming financial entities because of their freight activities.
As far as possible, so the hedging activity and the use of accounting measures for group capital, what we're trying to do is to reuse concepts that have already been established elsewhere. If the feedback is actually they don't work in this context, it'd be clearly important to let us know that. But we were trying to rather than sort of introduce a second definition of hedging or a second approach to accounting capital, trying to reuse concepts that are used elsewhere where we could. Catherine.
Well, I actually think I was going to really repeat what you've just said, is that if we should do freight in a different way, and you're not the first person I've heard say we need to think about that, perhaps we do need to look at classifying that differently. And also the hedging definition is something we'll look further at too. And as everybody has said on this panel, if you've got suggestions, throw them our way, please.
But not directly from the audience up
No.
to here now. Let's have 3 or 4 more comments on this. There are 2 together just here in the middle.
Hi, Samina from Cargill. David and Catherine, just to support the point about looking at and reusing the existing hedging definitions, that would be important. Where I think what we're looking at, and I think what Jeremy was alluding to, is really around the Q&A that's under EMIR that is causing some restriction. And we were trying to think about, what you're trying to do there is ask commercial firms to evidence, what activity do you have that's commercial? And we were trying to think about and come up with different ways of really providing that evidence, as opposed to trying to fit the Q&A into how we run our business, which would actually fundamentally change how we're structured. So I just wondered if you might be able to comment on other evidence you might have thought about that we could maybe look at and produce.
Stefan Feichtinger, AITA, International Emissions Trading Association. Under the trading activity test, under the ancillary activity test, there is one class that you propose for emissions allowances, not emission allowances and derivatives thereof. Now, are derivatives concerned here as well? We would say yes, because paragraph J speaks of emission allowances and derivatives thereof. Now, the intention under Article 2, Paragraph 1e is to exempt US compliance operators. The problem we are seeing is that under the current, is that nobody in the emissions market is only dealing on the spot market, which would mean, if we restrict the language under Article E to mean only spot market, which would mean that there is no exemption, practically speaking. So we wanted to know how this language is calibrated.
Let's take the last couple of questions on this topic in the middle.
Good afternoon, Sophie Tolley, BG Group. In relation to the trading activity part of the test, what steps has ESMA taken or do you intend to take to ensure that the information is made available to the industry so we can actually come back with some concrete analysis and proposals? And similarly, there's considerable uncertainty in the markets now relating to whether you as a company breached the ancillary activity thresholds. This is due again to the market data availability and the changing definition of commodity derivatives. And this uncertainty is beginning to and will increasingly have a detrimental effect on market liquidity. And we're wondering whether ESMA would consider an approach where the thresholds are set initially to cautiously higher level, but have a clearly defined process and timetable for periodic review and readjustment, as we have in the US.
Okay, thank you. And then a final question at the back.
It's a challenge for the cameraman. Hi, Christian from EX. I just want to come back to the balance between proportionality and political intention. I remember a working paper from last summer which said that ancillary means 50% and less. So the range is actually quite wide. And the point I want to make is about market liquidity. So under MiFID 1, commodities are generally exempt, while now they're generally in. So it's a very, very wide step from nothing to all. And the 2 tests you propose with those relatively low thresholds would probably trigger a vicious circle, meaning that once companies will drop out of the market, then of course the market share of the other companies will increase. And then if there were any firms actually to be able to benefit from the exemption, they could eventually then also fall under the MiFID regime and due to the costs decide to also drop out. And then you create a vicious circle of a couple of years with much less trading, more market concentration, worse spreads, and in the end you just have a market that doesn't really work any longer. And especially the power and gas markets have taken a lot of time to develop, and it would be completely against the internal energy market. That is one of the major political goals, even of the new Commission, but also in general with the Energy Union. So you would undermine a very big European project by financial regulation, and that would go largely against the intention.
Thank you. I'll ask Catherine just to wrap up in a second. I think just on the 50%, the discussion paper proposals from last year did talk about 50%, but that was a fundamentally different way of doing the calculation. So it would be inappropriate to compare 50 with 5 or 0.5. It's just a fundamentally different way of doing the calculations. They're not directly comparable. As we were saying, through the conversation, the policy intention is clearly to have an exemption for business which is ancillary to the main business, but to regulate as investment firm activity business which is not ancillary to the main business, and that's the purpose of the legislation, and that's what the technical standards are aiming at. But I think Carl Peter made this point right at the beginning. Perhaps unlike the transparency proposals or the tick size proposals we were talking about earlier, the margin we're talking about here is this difference between being regulated and not being regulated, and that's a significant difference. This is not a marginal change. That's a significant difference, and that clearly reinforces the point, as many of you have been making, that we need to try and calibrate this appropriately. So we're not ignorant to that point at all. Far from it. That very much is registered with us. Catherine.
I think it would be important to follow up on the hedging point that a couple of persons and the person from Cargill mentioned. I think your question was whether there was some thinking of departing from that. I have to say that so far our thinking was that the hedging definition EMIR is extremely wide and generous and covers almost all imaginable activities that could be done in relation to the future business or the future assets or the future cash flows. So the approach would be, as David said before, to try to depart as little as possible from existing definitions. So we would be interested on knowing exactly why those hedging definitions might be problematic, even in conjunction with the Q&As, and we can look at that in detail in the consultation, but the state of mind was to try to leverage as much as possible on the EMIR hedge definition, which we think that is extremely comprehensive, and that is one of the reasons for the figures that are in our consultation paper also. And on the point on the information available on the size, overall size, somebody mentioned that. We recognize that that is one of the problems in this way of measuring it. We have to live with a mandate in level 1 that says that we need to take into account the proportion over the overall EU trading activity, and the next question is, what is the overall EU trading activity? Because in a non-transparent market, you might not have that piece of data. We are fully aware of that problem. One possible solution would be that from now to the time this comes into force, better, more granular information from trade repositories on aggregate figures would become available. A different possibility would be to establish a monetary threshold, but we are looking into that. That's one of the keys in the regime.
Thank you, Rodrigo. Catherine, any final remarks?
Yes, just a quick one. On the emission, where do derivatives and emission allowances fall? I think that is a bit of a gap, so we are having to think whether they should be in their own category or whether they are more broadly in emission allowances. So if you have a thought on that, let us know. And I think my final thought is on the comment made about the vicious circle and liquidity will drop. I keep coming back to the point of if we calibrate the exemptions appropriately, so we are really talking about trading activity, and you have a percentage of a market which is speculative, not meaning that in a negative way, why shouldn't you be regulated like an investment firm? And is it a case that if people say this is going to be so detrimental that these profits are actually part of the existing profits today? And I think that piece is still missing when we hear these remarks about how damaging this is going to be from the market. Where does this trading lie? Is it to do with the business, or have there just been substantial amounts of more speculative activity going on?
Okay, we're going to draw a line there, otherwise we're not going to get through the remainder of the agenda. I think we've earned ourselves our mid-afternoon coffee break. It's now 5 to 4. I'd like to come back and start our final session at 4:25, please, and we'll turn then to position limits and position reporting. Thank you.